Everybody's all up in arms about what Judge Chutkan just did. Why didn't she enter the restraining order? Why is she letting Elon Musk continue to root around our most private information? Is that really what happened? Or is something bigger at play? Something that could ultimately lead to Elon Musk being banned from the government by the same Tanya Chutkan, the judge in D.C. Confused? You won't be after you listen to our reporting on Legal AF. Take a listen. All right, well, let's talk about Judge Chutkan. So Judge Chutkan gets one of the many cases involving Elon Musk and Doge. And in particular, while there are at least 2, if not 3 injunctions, restraining orders, stopping Elon Musk from rooting around certain computer systems like the Treasury Department and Social Security, a bunch of states got together, 14 of them, led by New Mexico. And they filed a case in D.C. They got assigned to Judge Chutkan, and they immediately asked for emergency relief about 13 different things. About Elon Musk can't be allowed to shut off federal and state contracts. He can't shut off funding. He can't root around and look in databases. And the judge, we knew it last week. The judge was like, let's separate this for a moment, ladies and gentlemen. You've got the merits of your case as to whether Elon Musk was improperly put in charge of hiring and firing and getting rid of funding and putting agencies through a wood chipper, his term, having not been properly appointed under the Constitution or confirmed by the Senate, nor really apparently holding any formal authority role in the Doge services or whatever that's supposed to be. And I'm going to ultimately make a ruling based on evidence presented to me about whether that is constitutional or not, or that has breached the separation of powers, because we don't like to live in a country where somebody has unchecked power to do the things that he can, who's not beholden to the American people or to any oversight by Congress in the process. That is separate from whether you have what's called irreparable harm. And I can't give you a prophylactic order about something that may happen in the future. You got to tell me what's happened to injure you right now. You need to have that for standing anyway. And what is about to happen that you want me to stop. And if you can cross that threshold, I'll give you your injunction. I might even give you a preliminary injunction, which is the next level up from temporary restraining order. But if you don't have that in my courtroom, I'm condensing 3 days of hearing. If you don't have that in my courtroom, then I'll see you at trial. I may give you a permanent injunction where I don't have to worry about irreparable harm. And we can just talk about mandatory things that I will force the government to do, or Donald Trump's administration to do. But I'm not going to give you your injunction. Now, she didn't give them the emergency injunction over the 3-day weekend. She held a Monday hearing in which she was very skeptical, not about the case, the substance of the case, what we call the merits of the case, but about the equitable relief that they were seeking and asking her to exercise her inherent authority. I'll just tell you straight, judges are loath to issue injunctions in most cases. And you got to hit the mark on all 4 elements in order to get an injunction. In my cases, I've handled hundreds of cases. I've probably been involved with injunctions and maybe a dozen of them. And the rest, the 90 other percent, is you just go to the merits of the case. You just have a trial, or you have a summary judgment, or whatever you're going to have. But you're not dealing with this mini trial about whether the judge can exercise power to stop a harm from happening that hasn't happened yet. And the problem with New Mexico and the other 14 states is they talked a lot about if. She even said it in her order, if. Karen, what did you make of the order? And then we can wrap it into what I think the states are going to do next based on a new filing that they just made.
I mean, look, a couple of things. First of all, it just, again, all of Donald Trump's claims that Judge Chutkan was somehow tainted, biased, corrupt, all the things he called her. She doesn't. She calls balls and strikes like she sees them. And this is one that, frankly, goes to a win, a temporary win, but goes to a win in the column of Donald Trump's, Donald Trump's administration. So I just think it's unfair that he has painted her with this with this lens of, people looked at her like somehow she was biased, and she clearly wasn't. So she calls things like she sees it. So, look, it seems, I understand what you're saying about irreparable harm. It seems to me that the plaintiffs here, the dozen or so states that brought this, should have brought some actual plaintiffs and added them as plaintiffs who will have irreparable harm. The people who are losing their jobs as a result of this, the funding that is not going to go towards medical research, or the people who aren't going to receive much needed food in other countries, et cetera. I mean, there's so many people who will suffer irreparable harm. And as much as you can say, oh, well, losing your job is not irreparable harm because you can be paid later. Tell that to the person who loses their house because they can't pay the mortgage. Tell that to the person who ends up homeless on the street, that's not irreparable harm, right? That's government employees. And so many of them are going to be impacted here. These aren't wealthy people like Elon Musk. This is a civil service career that so many people have as government employees, and it's just not fair that they're being treated as if they are somehow not human and not doing a huge public service. It's the civil service, and they could have easily found plaintiffs with irreparable harm. So that was the only thing I didn't love about it, but she found that the states didn't have irreparable harm, and therefore but she also added in there, look, I think there's a good merits argument on the appointments clause, because basically what she was saying was, look, Elon Musk has been appointed in violation of the appointments clause because she is essentially, he was essentially appointed without the advice and consent of the Senate. And so she said, look, I think you could potentially win on the merits, but you don't have this irreparable harm for a temporary restraining order. So, and they're moving so quickly that I do think he can do irreparable harm. I don't think it's hypothetical. They are doing things at lightning speed.
So they filed, the judge required them by 5 o'clock today to file a proposal on briefing schedule. They agree on some things and not on other. The briefing schedule that they proposed is which basically time out by April, and she would make a decision by then. Despite my recommendation and my hot take, the 14 attorneys general have decided they don't want to combine their preliminary injunction with their merits case. So they want to try to go forward and convince the judge that they've been irreparably harmed. They think they can do a better job with their guidance, I guess. I'm not sure about that. I would just go to the merits and get to the trial in the same period of time and make the ruling. Interestingly enough, the Department of Justice position is you should, judge, combine the two and just do preliminary injunction and merits. And I have a feeling she's going to do that, which is an insider baseball way of saying there's going to be one set of briefing, one major hearing, and one judicial ruling in this case from which people can take their appeal. And we will get a ruling from her sometime in April based on this briefing schedule that we will report on. And it's one of several cases that could lead to Elon Musk being removed from his role in government, no matter the fact that they lied to the federal judge and she caught him because they filed an affidavit in which they said that everybody keeps saying he's the head of Doge. He's not the head of Doge. He's not making decisions about federal workers or firing them or things like that. He's a special advisor to the president. He's like Anita Dunn, the one that worked for Joe Biden. I'm like, are you effing kidding me? And the judge says, let me remind the Department of Justice of their obligation to speak truthfully to the court and not to lie to the court in terms of the role of Elon Musk. So we'll watch what happens. But again,
I have a question. I have a procedural question for you. So in a case like this, they're seeking declaratory judgment, right? They're seeking not money damages. They're seeking a ruling that this is what the law is. This is what you can and cannot do.
Right.
And so is this something that in order to do that, do they have a trial?
Yes.
Okay. But is it a jury trial or a bench trial?
No, bench.
A bench trial. So they would have a trial in front of Judge Chutkan to determine this. She would rule, and then they can appeal that ruling. That's how this would go. Yeah.
Juries don't make declarations. The judge does. So it's one of those equitable powers that only a judge can. So if we had a case together, for instance, and there were a declaration count and a money count, the judge would do the declaration count and the jury would do the money count. And then the judge can decide whether, with the parties, whether the jury's going to do the finding of fact part or she's going to do the finding of fact part on the deck part. Here it's easy because they're only seeking a declaratory judgment. So it'll just be a trial on the merits related to that. And after briefing, look, it is what it is. I mean, there's only so much evidence you can put in. They're not going to have a fight over the facts. They're going to have a fight over the law. And Donald Trump wants to keep taking these appeals in order to get to the United States Supreme Court about his ability to decapitate all the leadership of all these departments and to have Musk do what he's doing. Donald Trump just declared, if you're a patriot, you can't commit a crime. And if you're Elon Musk, I don't know what his title is, but he's a patriot. And whatever he does is right. That's not what I voted for. And that's not how our democracy works. So the sooner we get these cases to the United States Supreme Court, and you and I can talk about them, the better. Let's
really quick before you move on. There was something I learned about in preparing for this part of the case, and it's the something called the Humphreys executor case from 100 years ago, which essentially it is similar. It's adjacent to what we're talking about, and it's really, and they're trying to essentially get these issues to the Supreme Court to get them to overrule this, to make this unitary executive, because it's basically the case that says, look, that Congress can require, by passing laws, presidents to show cause, such as malfeasance, before dismissing certain people, before firing people, right? And so you've got all kinds of positions in government that Donald Trump is either firing people or Elon Musk is trying to eliminate, and all of this is going to bubble up to the Supreme Court, and I think that Clarence Thomas has signaled he would like to overrule this as well and continue to solidify power in Donald Trump and get this unitary executive that we've been talking about. It's just terrifying how many of these, you see that they're planting the seeds in so many places, but they all lead to the same place.
Welcome back. You're on Legal AF now. Hit the free subscribe button. Help us to continue to grow this pro-democracy channel. And the Legal AF, the YouTube, and the podcast, Wednesdays and Saturdays at 8 p.m. Eastern Time, right here on the Midas Touch Network. The number one Midas Touch Network, home of two top 10 podcasts in the world. Midas Touch Brothers Podcast, Legal AF, all because of you, not because of us. We're just doing the content side. You're doing the watching, the appreciating, the interest, the activation side of this participatory democracy experiment we call Legal AF and Midas Touch Network. Help us continue to grow. Send that clip off to people in your life. Ask them to join us. If you already know about Legal AF, I thank you for being part of the audience. So until my next reporting, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.